pretty much exhausted. We've got the trademark presentation, which you'll see here. There's a little primer on copyright, which we sort of talked about in the introduction, but since we probably don't have a lot of time to talk about copyright, at least I'll give you a taste of it, and we can answer any questions. Maybe, I don't know if there's time afterwards. And then the last one is just a copy of an article which talks about the non-legal part of naming, what types of names we should be looking at, and we can refer to that in our discussion. So that's that. Format can be ask me questions while I talk. I think I can handle a PowerPoint and my notes if that's the way the programs usually run. And there won't be any breaks. Just kid about that. I have until 8:15. Doug, is that?
You can. I should think you would want to take as long as you like, but 8:30 if you want to go, or even further.
Just move me off the stage if you want.
We'll get a hook.
We'll try to move this fast. But before we go to the slides, I just thought, why is this valuable? I wrote some notes. Obviously, this is to help your investment. It sounds like there's people at different stages of product ideas, maybe getting closer to putting a product into the marketplace. But this is an aspect. This is branding. This is trademarking. An element of protection of that product. All that time and effort and money shouldn't go to waste by coming up with a lousy trademark or a lousy brand. So hopefully we can talk about that. Clearance is an important aspect of it. You don't want to be disappointed. You just come out with you don't bother to check. You come out with a name, and somebody sends a cease and desist letter, so you can't use that name any longer. Now you got to talk about changing your website, changing your name on your product. Spending a lot of money, so we want to talk about the clearance part of it. I think that's one of the more important aspects of branding, is making sure through due diligence that you're not impacting on somebody else's rights. Picking a good name, that'll help market your product. You may have a great product, but you may have a crappy name, so you may not be able to sell it because you got a lousy name. So you want to sort of match those up. And here's a PTO Gazette. There's 2 copies that come out every week. There's about 1,000 pages of trademarks. There's about 4 or 5 per page. So that means there's about 3,000 to 4,000 trademarks that are published every week. So that's a lot of people trying to trademark. I'm not sure how that equates to the patents that come out, but that's a lot of effort, a lot of names that are coming out. Not to say that they're all good trademarks, but they do make it through the process of trademarking. I got a sense of the audience, mostly inventors. I'm not sure how close to product introduction, but that's where we're going to talk about today, the product. So let's, 4 topics. We're going to try to go through common terms and definitions that you may or may not be familiar with. The clearance process, what that's all about. The registration process, what kind of steps you should take to get an advantage once you have selected your name. And the last one is on enforcement. You have a trademark. What do you have to do to enforce those rights? You don't want to lose your rights, abandon it. You want to go after infringers. You want to avoid a dilution. So those are the 4 sort of topics that we'll talk about tonight. Hopefully we'll get through them in due course. Okay, let's take a look at the categories here and what's available. All right, trademarks. Google. It's a good word. That's the symbol. Mercedes-Benz, slogans, just do it, product packaging, the Coca-Cola bottle. All these are protectable under the trademark law. Words, symbols, slogans, designs, packaging. Service marks, AT&T letters and the logo, service mark, meaning they protect services that are being offered versus products. Products, Deer Park products, computers, things like that. Tangible aspects are trademarks, service marks are the services. Both marks are protected under the same laws. There's really no difference. You may hear the difference. You may hear the word service mark at times. It's meaning to protect services or trademarks. Yep, Mark?
Jerry, could you back up just for a second?
Sure. Me back up. Yeah.
No, I mean, go back.
I mean, literally back up, yeah.
That's it. The product itself can be a trademark, and you have the Coca-Cola bottle there.
Sure. goes into an element of, is it functional? Is it distinctive? More often than not, that shape is not going to be protectable right away. It has to have some use and some association with the product and the consumer so that they recognize that shape. They don't have to see Coca-Cola on that. They just see the shape, and they know the source of the product is Coca-Cola. Could be whatever shape is protectable. We're kind of getting to the next elements of that.
So if you have something like that, or
Yep.
let's say
Right.
a French fry. French fry is another thing where it's out there. So if one company has a French fry, a picture of a French fry that's distinctive, over years it's viewed as that company's French fry. So that French
right.
fry then can be used as a trademark.
If it identifies the source, okay, if it stands as an...
Right, okay.
Right. Usually that'll take some time.
Okay.
It's not. It's basically they consider it not to be distinctive right from the start. It has to grow and become distinctive through activity, use,
Okay.
consumer recognition. Then they'll give it a value as a trademark at that point in time. Something like this shape of a bottle. More likely than not, you start out, no one's going to know where it comes from. But if it has some distinctive character and qualities to it, it'll achieve that. That bottle had, I guess when it started out, it didn't have similarities to other bottles that were out there. So it had that distinctive element that they want to protect. Yes?
Crazy to ask the difference between trademark and copyright?
No, not at all. Trademarks are protecting the goods and the services, or the identifiers for the products themselves. Copyright is going to protect the expression. Think of a book, the written word. Software, computer software, artwork. So that's the content that's being protected. Similar to patent, you're protecting your methods and all the technology. So the content is protected under copyright. You can have copyright in your book. You could have a trademark on the book. Random House is a trademark, so it could be a trademark for the book. And that's the differences. Oftentimes it's confused. People will hear, the news, the press will say, the copyright has been infringed when they talk about a trademark. Sometimes patent, so they interchange that.
Thank you.
I'm having trouble with the clicker here. So functions of trademarks: source, origin of products and services. Consumers are assured that they're getting consistent products. If they like Coca-Cola, they want to make sure they get the same Coca-Cola product. Goodwill, brand awareness is built up, and then the more distinctive the mark, the more protection you're going to get. To the right. Excuse me. So here's sort of the continuum of protection for marks. You want to start out looking at, from a legal standpoint, fanciful trademarks are protectable. We have Xerox copiers down here. We could use the word Google now. It's really kind of made up, so it's fanciful. We use the term coin words. So those are, from a legal standpoint, probably the highest protectable types of trademarks. Arbitrary marks, an Apple computer. Apple is a word in the dictionary, but it had nothing to do with a computer till today. I mean, we all know that it's associated with a computer. Suggestive trademarks, they use terms, descriptive terms, maybe combine them, chop them up. Citibank, maybe evokes banking that's in the city environment, but put them together, we have a suggestive trademark. Then you go down, you talk about descriptive marks and generic terms. Sometimes they're somewhat interchangeable. Descriptive, maybe smartphone today. At one time, companies tried to look at smartphone as from a trademark standpoint, but those words just lose value because of the prominent and types of use for that.
You have an R by the Apple, Xerox, Citibank.
Yep.
Sometimes you see a TM.
Right.
Does that mean the same thing?
Now, the registration notice, the R in a circle, means that you've gone through the registration process.
Okay. What is
The
it?
TM means that you're claiming trademark, but you haven't gone through and you don't have a registration for it. That's the subtle difference. You could have a situation where you have a registration, but you don't use the registration notice for whatever reason. And it's not mandatory, but you can.
So trademark is...
So TM means that you're claiming trademark in that word, that design, that scheme, whatever. Yeah.
But it has no legal bearing if you're just claiming it.
TM?
Yeah, if it's not registered.
Right. No, it has a significance, and you're claiming it as a trademark, but it's not registered. It could be a common law trademark. We're getting there.
Okay.
Sorry.
You can put anything you want on there.
Of course, yeah. I could put TM after smartphone, and until somebody challenges me, I've got a TM after it. I just can't put a registration notice. That's when I'd be committing a violation of the law.
Well, that legally you can't put.
You can't put the registration notice, right? Yeah, you could put TM on anything. Yeah. Sure.
Apple Computer was protested. I guess the name Apple was, there was an Apple Records, and the Beatles owned it, and they said it's diluting our trademark. You have to promise to stay out of the music business.
Right.
And Apple said, yes, okay, we'll stay out of the music business. We're just the computer.
Right.
Then they did the iTunes. Now they're in the music business.
Right.
Doesn't that dilute the Apple Records trademark?
That lawyer probably isn't with Apple any longer. There's probably an agreement. There is a consent agreement or coexistence agreement where the parties negotiated and went back in and decided that the world has changed. Maybe you give us a little extra money, the world could change even more. So there's probably some negotiations that we're not familiar with, unless there's somebody here that's familiar with it. But
I just want to say something. As you might know, the Beatles label was the Apple label, and because of this conflict in the issue about who owned the trademark in Apple, or Apple Records versus Apple Computer, Beatles songs were not available on iTunes until just recently, about a year ago.
Sure.
So is there an acid test for determining when a trademark is dilutive of another trademark?
An acid test?
Yeah. How do I prove, for example, that Crappy Bank doesn't dilute Citibank? Although I might say it differently.
The tests are generally likely to confusion. If two marks are going to cause confusion, then the prior rights owner has a right to stop the other's activities. There's an element when you're talking about dilution, which is another sort of segment of trademark law, which means there's not really confusion. Everyone knows the difference between the Beatles and Apple Computers, but the Beatles or Apple Computer, whoever has that right, has a stronger right, and therefore is entitled to protect its rights beyond the borders of what products and services may be related. And they are diluting it in a sense that there's no confusion, but they're diluting the value of that trademark. That is generally reserved for the marks that are way up here, okay? And we could talk about it a little more. It's not reserved for the marks when you're starting out in business. It has a value to you. You really want to look at, the sphere of protection that you have. If you're in the computer world, you want to keep people away from the computer world. You're not worried about the guy who's in, the music world at that point in time. But there is a scope. You got to be Coca-Cola. You have to be, maybe Google at some point in time. You have to have that strength in your trademark to go after people to that extent.
So let me see if I can understand this. Apple Records claimed that Apple Computer was diluting their trademark because people were going to confuse Apple Computer with Apple Records.
That's their position.
And how do you prove that?
That's their position.
Yeah, what's the acid test for confusion?
That doesn't mean the law would stand behind that claim. If they litigated it, they'd have to prove it. They'd have to go get consumer surveys. They'd have to really show evidence confusion. They didn't go that far. They sort of settled it, and they got what they want out of a settlement. And that's what happens a lot with these cases. Big companies will fight to a certain extent, then they'll give up, and then they'll come up with coexistence arrangements. Sure.
Wikipedia's got a very nice essay on this subject about Apple Core versus Apple Computer.
Okay, good. Yeah.
And there have been multiple waves because it kept progressing. They were sued originally just for using the word Apple, and they settled for $80,000, and then it moved on, and it was a $26 million settlement. But each time iTunes got more and more into music, the ante went up.
Sure, yeah.
And they don't reveal it all. But there's been a lot of money involved in this.
It's good to be king, I guess, huh? And just the other point on these trademarks, as you look at the stronger trademarks, from a legal standpoint, those are good. From a marketing and promotion and advertising standpoint, generally goes in the opposite direction. The marketing people like to use descriptive terms because it's easier for them to sell their products. They don't want to come up with fanciful names because then they have to explain what those products are. So generally, when I deal with clients, we're kind of, it's a tug and pull, push. What's right? Descriptive, protectable, and sometimes you come in, wind up in the middle.
What happens,
Yeah.
What happens for the large companies, let's say like McDonald's, that have a trademark combined with a slogan? Every time they often change their slogan to go with the trademark. So is there, can they, do they have to register every one of those combinations? Or does their trademark kind of lead the way?
Yeah, like McDonald's always stands, the same. It's McDonald's, and then they'll change their slogan. I can't remember what a slogan is today, but yeah.
Suppose another company uses that slogan as well.
If slogans can be protected like a trademark, if they can prove that use is causing confusion or will cause confusion, they arguably have a case. Slogans are difficult from a standpoint. Generally, when we talk with clients about slogans, they are maybe 6 months at most they're going to be used, and then they go on to another marketing campaign. So oftentimes we'll suggest that they do a clearance. They take a look and make sure they're not infringing somebody's rights, but not go to the extent of trying to register those slogans. Companies like McDonald's, they may go through the process. They may have the wherewithal and the finances to register everything that they put out into the marketplace. So those are, differences. Somebody starting out in business, you may come up and say, hey, I like this slogan. We'd say, all right, let's clear it, but, do you really want to try to register it if you're going to change it in 6 months? Because by the time it gets out of the trademark office, it could be a year. So. Trademark versus trade name, I'll kind of go through this quick. You can have, obviously, Coca-Cola Company is a trade name of a business, but it's also their trademark. Stands for a lot of different products. The only point there was sometimes if you're starting out in the business and you have one product and you name that company after your one product, if you decide to go into different product fields, you have to be careful because that one product, you may be bottled water today, but you may be computer discs the next day. So how does that brand translate to the new products? And you want to keep that in mind. Coca-Cola didn't have a problem with it. Trade dress is another area that you can consider for protection. Packaging, product designs, things that are non-functional and distinctive. Okay, the source is clear through the packaging. Take a look at that. I don't know if it's clear there. You see that? Anybody guess who makes that? Yeah. Guys probably wouldn't know who it was, but yeah. My wife doesn't know it because she's never seen it before. What's that? I don't know. It's from Target, honey. Don't worry about it. Yeah. So that's
Honey, you know what this is?
Yeah.
They don't know it.
Yeah. So that's again that's developed over a course of time. Today they couldn't come out with that box and people would say, oh, that's Tiffany. They had to develop a marketing campaign. Think about UPS. Brown. They made an effort. They told you we're brown. Brown. They have brown trucks. They have brown uniforms. They promote themselves as brown. So they're sort of telling you that this is our trademark, and that's important. Especially in trade dress areas where you can't just let the trade dress oftentimes speak for itself. You have to push the consumer in that direction. If you're intending to do something like that, color schemes or design elements, you want to make sure that that is brought to the attention of the consumer, so they understand that that's what they should look for. Look for a blue box. Look for the brown truck.
The functionality of that box is not...
It's the box is really not the protective element. It's the color scheme, the blue, because the boxes they come in all different sizes and shapes. Not colors, sorry. Coke bottle we talked about. There was a Supreme Court case several years ago that talked about the setting. It was a Mexican restaurant. Two Mexican restaurants were fighting over the decor. So the Supreme Court sort of set out some parameters for trade dress. Again, as we sort of talked a little about it, it's not something that you can get right away. You have to really work for it. You have to prove that these other elements besides names and logos are protectable, the colors, the graphics, things of that element.
So I have a restaurant, I have a color scheme, or I have a decor, or a methodology.
Right.
I file a
Trademark application? Probably not.
So
Right away, no.
So
No,
two restaurants are side by side and they both sell burritos.
Right.
And they copy the decor. You can't do that?
That you can't. What's the question? Can the other guy copy your decor? If you have a protected right, you can stop them. If you don't have a protected right, you can't.
But you only have
There's a lot of facts that we have to work
But you
through.
only have a protected right if you file?
No,
Okay.
no.
What's a protected right?
What's the question?
Well, I don't understand the
That-
distinction of protected right in what the way you just used.
Well, just from the start, you can't open up a restaurant and say, I have a Mexican restaurant. Nobody else can have a Mexican restaurant with, the same type of decor. You can't. That's not impossible.
Okay.
But if you have a restaurant that's been open for, 5 years and it has, that decor and it's recognizable and distinctive and people associate with that, the guy down the block, all of a sudden he opens up, it kind of looks like the same place. Maybe he's not using the same name, but he's using everything else. Then you may have a case. Again, these are these cases that are way on the periphery that tend not to be the basic trademark kind of cases. Those are the ones that are off to the side. Yeah, sure.
Well, that's the question I've had ongoing. You say that over time you can develop this, but if somebody comes out and they say, well, I did it first, or somehow I get it accepted before the other one does, or is there a process where you can say, I've been applying, finally it's been accepted, or is there any way to cover yourself if that was something you wanted to cover? Your color scheme,
yeah,
etc.
you can always file these applications, and oftentimes, depending on the examination and examiners, they may look and say, you have nothing. There's nothing here. There's nothing distinctive. We're gonna kick it. Then you're dealing with me and others that are trying to make arguments, spending time and effort and money to get those arguments through. Maybe they're going to be successful, maybe not. So those are all type of decisions. If you're ready, willing, and able to spend the money to get to that point, certainly that's an opportunity that can be discussed. Others are not in that situation. Yes.
So like that is the first one gets it in there, or it's whoever had it first?
From a trademark standpoint, trademarks are based generally on use and priority. If we're talking about the restaurant scheme, you're contending with, well, I opened the restaurant up in January and you came in March, then you would have, if you have a right, you've got a priority. Filings are not required. You can have a common law trademark right, so a right of use can trump somebody who has filed an application if you can prove, that prior use. That's a little different from, I can't speak on patent. We have Mark and John here can speak more on patent, but that's where it sort of varies. You can have a trademark right. Just where we talked about the restaurant is building up a trademark right as it's using it versus a filing like a patent. Domain names. Today, very important to consider as you're looking at new business and new products, looking at the .com, .net, .biz, and other spaces that you should look at. It's generally a lot cheaper to secure domains now than have to go back in after you've had some success and somebody has taken your domain name and now wants to either sell it back to you or will fight you. So, it's something you should look into. Another thing that we're seeing now is the social media, Facebooks and Twitters. People are losing their trademarks because somebody has coined their trademark as part of a Facebook name. Now we have to go through a process to go to Facebook and ask them to get it back, and sometimes Facebook is agreeable and sometimes not. So some of these things are easy. You don't need lawyers, obviously, to register domain names, so it should be something you should seriously consider as you're looking at your product. Product name should, and we'll talk about this a little in clearance, product name should sort of match up with your domain name, or vice versa. Sometimes you'll have a domain name that you can get right away, but you may not be able to get your product name. So you may look at what are your options, and how do you deal with that?
I got a question.
Sure.
Should products really have domain names, or should that be associated with companies?
Product names, yes, you should have domain names. AT&T, Google, whatever products they put out could have a domain name. It all could go to one site, but that product name, because that's where we find we spend a lot of time infringing, dealing with infringing.
Who's the manufacturer? You look at that product. So if you see a lot of companies where they might sell 20 different products in 20 different industries, each one of the products has their own website or a domain name.
Yeah, I mean, if you consider Microsoft Office, there's probably Microsoft Word, PowerPoint, Excel, any one of a number of different products Microsoft makes. I think probably none of them have their own domain names.
Oh, they all do.
They do?
Yeah, because that's what, if you leave that space open, the guys who are knowledgeable will go grab that space, and then they'll wait for Microsoft, they'll wait for Google, they'll wait for Doug Lyons to show up and say, that's my trademark. Well, we got it. Now we have to negotiate to get it back. So if you can go and grab those, and that's what we will recommend to a client. Even though they have a brand name, but they have a product name, they oftentimes want to match that up. They want to go through the embarrassment of having a trademark out there being sold, and somebody else has the domain name. So, traffic going in the wrong direction.
So when you start a company, most of the times you incorporate, most law firms will do a search for a domain name, trademarks, the whole thing.
Yeah, that's the company name.
No, everything. If you have a product, if you tell them, I want to call my company XYZ company, my product is ABC, they'll do a search for a domain, trademark, anything that's associated with those names. It could cost you $100,000 to brand your product, have it followed by social media, and then you realize you have the wrong name.
Well, let's not get everybody nervous here. That may be an overstatement, $100,000. But I know this can run the gamut of where we are. But if we have guys starting out in the business, I don't know if they can expect that they're going to spend $100,000 at this juncture. Okay.
You
Sure.
both touched on what I wanted to ask you. If you talked about this before I came in, I apologize. But if you're an independent inventor, let's say you're in the toy and game industry, which is one industry where an independent inventor may actually be able to do something,
Sure.
make a living. And you have to, you want to protect the trademark. You go out and file a trademark application, but in order to keep a trademark, you have to use it,
Right.
as you mentioned.
Right.
So the patents application could take a year or a year and a half. First you have to write the patent application and file and all that. These things could take, let's say, 3 years. You've already filed your trademark and you haven't used it. So you have to keep extending the application until you use it. You intend to use it, I guess.
Yes.
Whatever it's called.
Yeah, right.
That to me presents a real challenge for an independent inventor, because not just the cost of doing that, of keep filing and having to extend it, because it's not out there yet. It can't be out there. And you haven't even gotten a patent yet. And once you get the patent, you have to try to license it.
Right.
The challenge, it seems to me, in getting in protecting a trademark before you have the patents is cost. And the other challenge is possibly revealing, hinting to some other game inventor or some other game company,
Right.
what you're up to.
Well, that's a good point, but the law prior to 1989 required you to actually use your trademark before you could file for it. So you were in a quandary. You couldn't do anything. You couldn't establish a trademark right until you actually had trademark use. 1989 and after, you have the option to have trademark use for filing or an intent to use, proposed use. So you take a plan. That's what a lot of companies were concerned about. They had to conjure up use. They had to ship a product from New York to Connecticut, and they have use, so then they could file an application. That wasn't acceptable to a lot of companies, pharmaceutical companies. All these companies had a long shelf life for the product introduction. So they introduced this law, intent to use law. So it basically gives you, your filing application gives you about a year and a half to notice of allowance, and you have another 3 years. So you have 4 to 5 years to get it into the marketplace. I'm not sure what else you could.
Running the risk of hinting to other people, hinting about what your toy is all about.
Well, if your name hints, there's nothing you can do about that. You can keep it quiet and hope that no one else chooses that name. Or your description of your product doesn't have to be so specific. It could be whatever character's name.
What if it's worth the gamble to just not do anything so you have a patent?
Well, again, that's a process of, do you need the name right away or not?
It may help you license a patent if you have a
Right.
really catchy name.
Yeah. So those are the risks. That's what, if you're talking to a lawyer, you'd bounce that back and forth and decide.
There's no standard answer.
No, not really. It's industry based because the pharmaceutical companies say this is great. We get to extend for 5 or 6 years until the regulatory approval, and then if it doesn't happen, they just refile applications and keep refiling. Until something happens. They have the money for it.
Right,
Yeah. So there's a compromise. I don't know what you would say. What the application should be held in suspension until you decide, or when you get them.
I don't know. If I could write the law. If I could write the law, seriously,
Yep.
I have the intent to use things a really long period.
Yeah. Well, the problem is that becomes just a game for a lot of people, and it just ties up the trademark office. You can imagine there's 4,000 trademarks filed each week. That would probably be triple the size. There's another addition that goes with that. I didn't want to lug it in here. So you'd triple that. So you'd have there'd be every conceivable word would be trademark. So all right. Trademark clear. I think okay. Yeah. The due diligence aspects of clearance. I think this is one of the most important aspects from a business standpoint, what you should be doing. Compared to registration, you want to make sure that the product names, logos, are going to be, successful in use once you hit the marketplace. So you want to find out ahead of time. I don't think you want to gamble. You don't want to go into this blind saying, all right, here's the name I'm choosing. I'm going to go sell the product tomorrow. I'm hoping nobody comes after me. And then another, point I would make, this starts the process of a team effort. Lawyers, entrepreneurs, product managers, marketing people, everybody, naming consultants, everybody's part of this team. They should kind of understand what the objectives are, going forward. Should you, choosing a name, do you really need a protectable trademark? Some of those fundamental issues should be, vetted at some point. Are you talking about a product? Are you talking about your business name? We talked about whether or not your business and your product name should be the same. Is this a product that's out in the marketplace and all you're doing is putting a new feature to it? There are a lot of clients that, they just want to add a feature, so they want to come up with a new trademark so it sells better. So some of those things, so you vet that out. You discuss whether or not you need a protectable trademark, or should it just be a descriptive name, and you go through those steps. And one of the handouts, it's a one-pager. It talks about some of the issues that you would think about during brainstorming. Those are non-legal issues. I think Suzanne Paquette in the back here, naming consultant. Those are the things that a consultant would work with you on to come up with the right names for products. Timing. Obviously, it's always better to start early in the process when you're naming. It gives everyone involved, whether it's the lawyers doing the due diligence or people that are doing market research, time to understand and look at all the issues. If we do a trademark search and we find that there's a use of a trademark that's similar to the proposed trademark in Utah, we have to look into that. Is that going to be a problem? Are you going to sell products in Utah? Are you going to be in the West? So you want to have a chance to sort of go through that process and understand the risks that are involved if you just go out and introduce a product into the marketplace without really vetting all of those types of problems. Market research may tell you, you may have a couple different names. Well, this name's better than that name. So you may want to look at, how does that work? What's the process? Yep.
Can you rely on a Google search? I mean,
can you?
Can
you can. I can't.
Can one rely on a Google search to at least screen out the obvious?
Yeah. Yeah.
Google that comprehensive that if something is filed somewhere, it's going to pick it up.
Yeah. That's a couple of slides down. We talk about the search itself. But that's what we try to recommend to clients. They should be looking at, web searching. They can go to the PTO website and do searching. They can go to a lot of different free sites. They get a sense of if they have a name and all of a sudden they find out that they want to sell, bottled water, and they find out that there's an incontinence product under the same name. Ooh, maybe we want a different name.
Google will pick up everything that's in
no, Google won't. This is the U.S. Patent and Trademark Office website.
So that
Google, you're just searching different websites. This is specific. This is uspto.gov. It's noted in the handout on page something. I can't put where it is. It's in the handout. I can't find it. But that's the website. You go up. You can search. It's pretty easy to go through the process to go search it, and that's where you get a sense of what kind of records are out there. We call those preliminary searches.
Who doesn't know every record that's in the USPTO files?
If I may, I don't know about the trademark side, but on the patent side, the patent information is retrieved when you put in a request. It doesn't exist on a static URL. So Google can't search it and categorize it.
Yep.
Thank you.
PTO site, you can go in there. It's two searches. You can put in and just say, I'm looking for McAllister. Put it in, and you get any trademark that has McAllister in it. Then there's a second type of search where you can put in McAllister and the classes or the goods, so you can narrow the search. So if you're looking for, rocket ships, McAllister, you'll go in there and you'll find one maybe, or tugboats, you'll find one. You narrow it down. Usually that happens when you have a name that's fairly common. And you put a search in and you find out there's 1,500 different, variations of that. So now you want to try to squeeze it down. And that's helpful. You want to look at that. You want to come to the table with knowledge of what could happen if you go into a deeper search. And you'd rather spend your money wisely than have the lawyer say, I just found a search. Your name is right on the first page. So, yes?
Let's say you apply for copyright or trademark. Is any part of that process public information once you do? If so, is there a way to hide that because you don't want to share that with legal companies?
No. For trademark, everything you file is publicly filed, and it's electronic today, so it could be public probably within a couple of days. So the trademark you're filing for, your name, your company name, your address is a public document, and the description and class of the goods that you're filing for is public. If you're using it, you file an evidence of use, that's public. So all that is public data. Copyright is a public record also. If you have, this is sort of an aside, if you're trying to register a computer program, you have to file your source code, but you can file 25 pages and redact out what you think are trade secrets out of it. So it's sort of a non-public filing.
And when you say public, is it searchable on the USPTO site?
Searchable on a PTO site. The Copyright Office records aren't as searchable. The information could be found if it is a public record, so you could either try to find it or you could hire somebody to find it. So there's questions sometimes when you're looking at a patent, maybe business method may encompass computer software. If you want to try to copyright the software, you got to be careful because that could be a public document. Timing. What else? Timing. Sure.
In patents, they have a wrapper file which you can gain access to. Do they have a similar thing for trademarks?
Mm-hmm. Sure. Yep.
And is that also something that you can gain access to through the public website?
Once you go on that website, if you go in and you find, let's say McAllister Tugboat, right? You go in and get that record, then you'll go into the next page in, you'll see everything that's been filed. If it's current, if it's an old trademark, you may not get all the records, but you'll get everything. You get the application, you'll get the PTO's office actions, you'll get our responses back and everything that's filed with the trademark office. It'll be there. Just on timing, obviously, kind of waiting till the last minute. Hey Terry, we wanted to clear this name, and we're going to introduce the product tomorrow. Can we do it? Technically, you can. These search firms will, they'll immediately do a search for you and turn back results in an hour. Okay, but it'll cost you, an arm and a leg for that type of service. We obviously don't recommend that because again, you don't have a chance if that Utah mark comes up, you're going to have no time to figure out how do you get around that mark. So timing is, that's an element that you really have to keep in mind. Other things happen, we're going to go out with the product in a couple of days, and the boss really loves this name. Okay. How do we tell them that, when we did the search and there's a conflicting mark? How do you get around that? So, if you build in time, maybe you have a chance to sort of socialize and kind of talk about the problems. Product managers, sometimes big companies, they're there for about 6 months and then they leave and they go to other divisions. So they may look and say, I'm not going to be around when the S hits the fan. Just go ahead. They're gone and the problem is there. So it's helpful. And the same is true for anybody that's working as a team. The naming consultant has to have time to sort of vet all the issues and get all that information. So that's sort of the pet peeve, and I was just sort of interested since we're in we're in the kind of the hurricane season right now. You wonder if there's somebody at the National Hurricane Center. Tonight, how do we what do we call this thing coming at us? They've got a list. I found there's a list. National Hurricane Center. They have all the names for 2011. After Irene, it's going to be Jose and Katia and Lee and Maria. So they're prepared. They're prepared for it. Could you imagine if they, what are we going to call this thing? We'll call it Gloria. No, I don't think so. We had a Gloria, and that wasn't too good. So it's sort of an exaggeration, but that's what happens. You want to have time to let it breathe and think about it. You want to have you want to select the best name. The other thing I see a lot of times is last minute. All right, we're gonna sell bottled water. What's the name? How about clear bottled water? Descriptive. But they don't have a chance to think about it. They're sort of running fast. So if you think about it, have a chance to think about some of the qualities that you want to promote when you sell that product. You guys probably all have great products, so you don't want to hit the marketplace with clear bottled water because your competition probably can come in right after that. I worked for 9X, I think you see in the bio, and this is in 1980 time frame. And voice-activated dialing was hot. They had the technology, and they were leading in that advance. So it's exciting. They're going to do this, and so they came out. This is going to be the new brand for this service. And what are they going to call it? Voice dialing. That's it. So the technology people. And nothing against you guys. You have a focus on something, but maybe you have to move it to the marketing and branding people so they can help sell it. Voice dialing, right now, it's just sort of I don't know if it's even being used, but it's just kind of common, generic kind of word. So they lost an opportunity to name something, and it's probably true of a lot of different products. So, availability. Let's talk about that. Notice the bolding, highlighting here. All proposed trademarks should be sent to your legal counsel. Yes.
I was going to say, we were trying to name a company around 2000 in the internet space, and one thing I learned about this was that you want to do a quick check on your own before you bother your attorney with it. We went through 350 names
Right.
that everybody in the room was convinced were novel. And
Yep.
every one of those domains was already registered.
Yep.
So without even looking at trademarks,
Right.
domains were taken. Words that we couldn't even, we just started taking random half words and gluing them together.
Mhm.
Every one of them was taken.
Right.
So to say nothing of the problem of .com, .biz, as you said, and then you go to .tv and all the others, and with and without hyphens, it turns out you think you're safe, and it turns out the word's registered with a hyphen, and you were using it without.
Yep.
This,
Yeah, there's a lot of tricks of the trade. Yeah, and I think that just goes to, the more time you put into that aspect of your product, the better it will be. Because if you try to do that, 2 days before you're introducing it into the marketplace, you're SOL. Yes?
When people fail to pay the fees on their trademark, I think they can lose them.
Yes.
And can you pounce on those lost trademarks, or is that a very dangerous thing to do?
Well, we talk about abandonment later on, but basically what happens is you have a registration, and if you fail to renew your trademark, it will be canceled in the U.S. Patent and Trademark Office. However, you could still be using your trademark. You just forgot, maybe you don't have, lawyers to remind you that you had to file papers. So you lost the registration right, but you're still selling products out there. So you still have a common law trademark right that's available. So if you decide that, you see that, McDonald's didn't renew their trademark for milkshakes, I'm going to go grab it. So you file an application for it. McDonald's will probably contact you and say, that was an error on our part. You better give up your application because we're going to oppose you, we're going to challenge you, we're going to do everything. So that's an issue that comes up in a search, trademark search. We may find that, someone abandoned or canceled a registration or an application. Doesn't necessarily mean that they've given up completely on their rights. So that would be something you'd want to investigate and look into, depending on how close and how serious it was to what you're planning to do. These are some, and we've kind of talked about searches. This is what you're looking at. You're looking at filings. You're looking at use. We talked about common law rights. What we search. You're looking at registries. You're looking at directories. You're looking at the internet. And at the end of the day, what you're looking at is you're trying to figure out, are the names that you're proposing to use or name, how close are they to other names that are out there? Sight, sound, and meaning is one test. You're looking at the products. How close are the products? I want to sell this trademark for toothpaste, and somebody's got it for a lawnmower. Is there going to be confusion? I don't think so. What are the trade channels? Who do you sell to? Who are the customers? Then you look at, should you be wary of, the big McDonald's or the ATTs or the Googles of the world that have trademarks. So maybe you want to stay away from those stronger trademarks that may try to assert themselves. Even though you don't think they're a problem, they may still come after you. We've talked about the types of searches. What we call a knockout search, a preliminary search, and a full search. Knockouts, are just quick searches. Make sure that there's no obvious trademark that's going to impair your ability to use or register. And then you're doing a more detailed search. Once the client has, agreed that they want to go after that trademark. Another point is we try to suggest to clients, and they should be looking at multiple names. They don't want to just go with one, although it is more expensive, obviously, and then we counsel that. But if you go for one and one falls, then you got to start the process over again. So you may want to look at some variations and numbers. And then Sometimes we'll suggest you go through, you may have 20 names, maybe you start with 5. Those 5, if something happens, these fall out, then you go to the next 5, the next 5. You try to stage it. And it's all really just financially driven in that regard. Part of that team effort is really disclosing to who is looking at, who's doing the search. The product information, the details. All of that is valuable when you're looking at a trademark search, so you understand. When something comes up in the search, try to evaluate it against what the information you have. It's good to let the searching person or the lawyer know geographically. Are you looking at the U.S.? Are you looking at Europe? Are you looking outside of the U.S.? We haven't talked specifically about foreign rights, but they sort of blend with the U.S. The same kind of issues. If you're looking at those countries, you should be doing similar types of things, searching and looking at the registration process. We talked about the knockout, meaning that's something that the client can certainly handle. Going the wrong way. What do we need to search? All of those items that came up. Names, brands, designs, slogans. Even if you're going to do a domain, but you're not going to do a trademark, you may want to do some searching on that. There's other variations here. The last one, for example, if you already have a trademark for covering one product area, you want to expand it into a totally different area, you should look at trying to do some clearance. We have a client now that had a trademark in a category, wanted to expand, and once we did the search, we found out that somebody came in after their filing and got into that area, specific area. So we were now sort of looking at what the options are. So those are some things before you decide that, well, I already have a trademark for toothpaste. I'm going to go sell computers. I have a trademark. I'm going to go do that. And you have to be careful about that because you can't always extend into some of those areas.
Can I ask a question?
Sure.
Follow up on the accounts question. What if a company goes out of business that owns a trademark?
Uh-huh.
For example, I used a trademark for the word Crossroads. I was approached by the attorneys for Lehman Brothers that had a service called Crossroads. We made a deal on our licenses from them
Right.
for particular use. But then they went out of business. And I never heard from them again. So did that automatically go back into the public domain, or is probably on somebody's books as an asset after the bankruptcy, but you're obviously not using it?
Right, but you're still the owner of the trademark. You license it to somebody else. Is that
No. I was not the owner.
right?
I was the licensee.
You were the licensee.
So the owner went out of business.
Right. Well, again, if you have a contract with them, you have to look at the contract. See
It
what
no longer exists.
do you want to do?
Well, how would that affect my rights?
You still using that trademark?
Yes.
You should probably look at going in and seeing what you can do to become an owner of that trademark.
Right. That's the council's question. So.
Yeah, it's hard for me to give you legal advice without, it's not a lawyer-client setting here, but, the facts are very specific to what you're talking about. It's something that you should look at, because obviously if you don't have a party that has the trademark interest, you may want to look at what can you do. Your agreement with them may dictate what you can or can't do. There may be somebody who bought that company and has the interest. I don't know, where all these things lie, but...
My question is sort of a use it or lose it. Obviously, no one is using that word, that service mark, Lehman or any successor. So, does it go back in the public sector if you stop using it,
Right.
and therefore somebody else can come?
Right. A trademark use, that's cease use and abandonment could revert back to the next person who wants it. Abandonment calls for, stopping use, ceasing all use with an intent not to resume that use. So, those factors, if you're still using it, you may have some rights. Now the question is, how do you get rid of the guy who owns I assume it's a registration in the U.S. Trademark Office?
Yes.
Right? You may have to go and try to petition to cancel. There may be some steps that you have to take, unless I have something incorrect. But yep.
Does using your own name offer you any leverage? If my name was Trump, for instance, could I get away with Trump, whatever?
Mr. Trump?
Well,
You can, if your name is, David Trump, and you're in the real estate business, you can certainly use your name, David Trump, in the real estate business. You may have difficulty just using Trump as a trademark or an identifier because of, what has preceded you. But your ability to say who you are, and again, that's going to be conditioned on a level of confusion. If you say, David Trump real estate, Mr. Trump may come after you. But if you use it in a way that's clear that it's, David Trump real estate business, you're not going to cause any confusion. There may be. Somebody may think, oh, my God, you must be his, brother-in-law or something like that.
I know you sent a playing card out.
Yeah. Again, there's this level of these guys who think they have rights, and there's the lawyers who want to, enforce those rights, and there's legitimate rights. These guys, he can step on whoever he wants to. At the end of the day, most guys aren't going to fight the battle. Okay, I'll change my name. Does he truly have a legal right to stop you from doing that? Yeah, it's probably questionable. As long as you were doing things that aren't causing confusion. That's really, again, it's always the question. Are you causing confusion? Ernest and Julio Gallo. There was always battling over who had the Gallo name and rights to it. The wineries always have those issues, and if you can identify, your name, you could be in the wine business. But I think there's always going to be battles over those kind of rights. There's a couple of cases that we'll show later on if we make it that sort of talk to that point. That what you think is right and what you've consulted with your lawyer, you think, well, I think I'm home free. There's always somebody else out there that's going to question that and look at it. And if you're a Trump, the lawyer may be kind of in his ear saying, hey, look, you can't let this go. You got to stop these guys. You don't want all these Trumps, these little Trumps out there. Sort of touches on this slide here. Are you home free? You've talked to the lawyer. Hey, everything looks good. Just to go back, what generally a lawyer will give you if you engage them, do the search, and they will provide you a written work product saying, we've reviewed the search, we think the mark is available, and here's some issues like that. Our firms tends to be a little concerned about is if we memorialize a negative and write it down, saying we found this mark and we think it's confusingly similar to your mark, and therefore you shouldn't go ahead and do that. Oftentimes we'll have a conversation with the client, talk about it, and not memorialize it so that there's something sitting in your file that says you shouldn't have done that, and then you go ahead and do it. So we try to balance that. But that's generally what you'll find. You'll get a search report back with an analysis of the references, the key references, and a strategy plan. We think you can go ahead. We talk about the registration process.
That would be an issue for an investor. An investor comes along and thinks that you're getting this new hamburger chain called McDonald's. You've gotten a written work product. Because the attorneys wanted to be careful and not put it on the record that they thought that the name was already used.
Right.
They don't write it in the report.
Right.
So now a dishonest inventor might go out to a venture company and say, I'm squeaky clean, look, here's a written report, came from your company.
Right. But yeah, that's true. But that investor's got probably a gaggle of lawyers that are doing due diligence, and they're going to look, they're going to see, wait a minute now, we don't have a report that identifies the risks and or what the action plan is. So oftentimes that'll be discovered at some point. That I blathered on these issues. I thought I'd give you a test here. Would you be confused? Here's two trademarks: colon cleanse, move it, and colon cleanse. Confusion?
I'd be confused.
You're correct. And here's some reasons why. They go on to talk about, the similarities to the marks. The products are similar. They have suggestiveness. Consumers are going to think there's some kind of relationship there. Since we're kind of bugged for time here, let me. It's in the paper. We can read the conclusion. The next one, Dynatech, engine exhaust system components, and Dynatech for ignition systems for motor vehicles.
I'd be confused.
Dilutes the trademark.
Confusion?
Yes.
You read the case.
I would be, but I read it.
Confusion? Nope. We're gonna let this one go through. Yeah. Because they said, you'll see it in the first paragraph. Hey, all things being equal, you said that you're a specialty racing product ordering service. Okay, so to them, that's enough of a distinction in the channels of trade for them to think that there's not going to be confusion. There's going to be a type of consumer here and a type of consumer over here, and they're not going to be confused.
Plus it's spelled differently.
Yeah, that's an aspect, but generally is not a deciding factor. All right, next one. Reef Safe sun care lotions. Reef sunblock preparations. Reef oil. I've lost everyone already, huh?
I got lost in the last example.
Yeah. Too much confusion. Okay. The common use of reef, the fact that the word oil is descriptive doesn't really cut it. The applicant in this case said, well, we're different. We're reef safe and they're reef oil and this and that. So, they try to throw a lot of arguments why there's no confusion, and you can read through this part of it, but that's what happens there. Let's talk about a couple of infringement cases, too. Urban homesteading, first ascent, first ascent. Okay. Okay. Here's a trademark registration for urban homesteading. And there's an E out of educational. There's not a educational service. It's an educational service. It's a registration. This isn't really a test. I'm not going to. And the owners of this trademark saw that somebody was writing a book, and the title of it was The Urban Homesteading or Homesteader. The Urban Homestead. So the trademark owner went to Facebook and said, you can't allow them to use the name on Facebook. Facebook decided that, well, we're going to take the page down. They asserted their trademark rights. And this turned into a big sort of brouhaha because of, people who do urban homesteading, which I have the reference here. It refers to a lifestyle of self-sufficiency and sustainability. That's what I hope my son does at some point in time, but he hasn't reached that level yet. Still at school. Farming, just sort of living off that lifestyle. And basically, these people are up in arms. They're saying, well, how can this entity claim an exclusive right to these terms, which seemingly are used by everyone to talk about this? And that's what's going on here. And this is just sort of an example of sometimes you have a trademark, you try to go after somebody, and it kind of slaps you back in the face because now there's a YouTube campaign going against these people. There's an Urban Homesteader Day of Action that are kind of attacking this effort to try to claim an exclusive trademark to urban homesteading. So if you're thinking about using that trademark, you better be careful. And then this last one is just First Descents. Non-for-profit company is going after Eddie Bauer. They're fighting over First Descents, First Ascent, and First Descent. And I don't want to belabor these, but basically, here's what's happened. They must have had a clearance search done at some point in time, and somebody said, "Yeah, go ahead and do it." So they went ahead and did it. And they didn't know about Eddie Bauer's activities at one point. So now these parties are fighting over who has the first rights to first ascent or first descent. So the lawyers are kind of duking it out. There was some trademark filings that go back years that Eddie Bauer has blocking the first offense filing. So it's just it's kind of a mess. And this is a not-for-profit battling, a large clothing manufacturer. The point here is not to talk about the legality of what they're doing, but just to say, when you're doing clearance, it's not a science. You could run into problems. Let's kind of move on. How are we doing on time here?
How many pages do we have left here?
We got we're past the halfway point. Registration, it goes pretty quick. All right, let's assume we got a name. Oh, what time you guys want to? You can. You want to?
10 minutes.
Yeah. We'll go through this quick. Yep. All right, you've got a name. You did a search. You got a lawyer that said that search looks good. What do we do now? Well, let's make an effort to protect our trademark. U.S. You can we talked about it. You can file or you can have use, trademark use. Overseas, more often than not, you can just file an application. You don't need use. You don't even need to say that you have an intent to use. You could just file your application. And as long as you continue to use the mark, you're going to have a trademark. Again, another point, when you're in the process of thinking about registering a trademark, you should look at your domain name issues and register your domains at that point in time. It becomes a lot cheaper to register a domain for $20 than maybe a year from now have to file an action at WIPO, what we call a UDRP action, an arbitration, which can cost thousands of dollars to get that domain back. So it's kind of important to look at the registration. Basis for filing, we talked about a little. Intent to use and actual use. Today in the trademark office, everything is done electronically, so it makes it easier for individuals, entrepreneurs to sort of go through that process. They have some easy steps to do that, and that's a reference to the USPTO.gov website. It has a category for searching, and then you can go in and look for filings. In the U.S., you can't get a registration until you show use. Okay, as I mentioned, for foreign marks, use requirements are not part of their process there. Tends to be a little longer in some jurisdictions. Some come a little faster. And there's a Madrid Protocol process which allows for registration. The U.S. is now a member of that treaty, so a U.S. company, U.S. individual can use the process to file and register trademarks in multiple jurisdictions. Most of them are European-based, Asian countries. South America countries are not part of it at this point, although some of them are moving towards it. So that makes it a little easier to get a process started. It's almost like in the patent world, PCT type filings, I guess. Here's some of the benefits from a registration. Presumption of ownership. That's important when you're going into a fight. At least you got something, you got a piece of paper standing behind you. Yes?
I'm confused about something.
Okay.
Before we were talking about, you could register a trademark.
Yes.
But you didn't have to use it first. You just keep registering it. You hold on to it until you get ready to use it.
Yeah. But what he really meant, what we were talking about is keeping the filing alive.
Yeah.
Okay. Just the filing, not the registry. You don't have a registration until you show use. Right. So your application can be maintained until you show use. That's that little part of it.
But it's still public domain.
Yes. No.
When you're apply, it's still public domain.
It's public domain, or it's available to anyone seeing it. Yeah. Doesn't mean that someone can take it. It means that somebody's already filed for it in that category. Yeah. It's available to. Yeah. Right. Yep. Sure.
When you offer something for sale, is that the same thing as use? So, for example, let's say I go to Kickstarter.com and think, I'm going to sell my next big product.
Right.
And I hope somebody will fund it, and I'm calling it the XYZ thingy. And now, is that use? Or is that, it's not use, I'm just offering it. So that offering it for sale is not use. I actually have to sell it. And it has to be funded.
Yep.
Ah, that's very interesting.
Yep.
So what if I donate it to a, a charity and they're using it? You have to turn a profit on that thing? Is that the description you use?
It has to be in commerce. It has to move. Okay? That product has to kind of move. It has to be sort of legitimate. So you're saying you sold it to a not-for-profit? You sold one? You gave one away?
I gave one to the United Fund.
What do we want to do with it? Do you want to have a trademark, or do you want to just give it away?
I want to demonstrate use.
Yeah. Well, that's not bona fide use. You have to show that you're in commerce selling your product. That's what happened before they changed the law. You used to have to say, well, I can't. I want to get Deer Park as a registration. Okay, Terry's got to take this bottle and he's got to go to New York and have it sold in New York in commerce. Today, what they said is, we're going to balance it. We're going to say you don't have to go through that charade, but when you are ready and want to show use, you have to be a legitimate, bona fide activities. So if what's your product? Tell me what your product is. It depends. Everything depends on what your product is. If you're selling a $1 million machine, is different than selling bottles like this.
So somebody decides it's a judgment call. So there's somebody sitting there working for the government deciding.
Part of it, yeah. But these kind of issues are ones that are looked at by either courts or the Trademark Trial and Appeal Board. So these are not just examiners. These are guys trained in adjudicating issues, especially the judges. So they may look and say, you filed an application, you gave your product to a not-for-profit, you claimed that was use in commerce, and the government gave you a registration. You got a piece of paper, okay? 2 years later, mega company comes up with your trademark, your product, selling it legitimately. You try to sue them, and they come back and say, let's take a look at your application. Maybe you didn't do it right. So now they're going to say, I think that's fraud on the trademark office. Now all of a sudden your registration is gone, and you have no right to go after these guys. So again, that's sort of exaggerating, but that's what you have to be careful about. What it is, what's your commerce? That's what they look for. They say, if guys in your position were selling bottles of water, this is what they would be doing. That's what you have to do. If guys are selling $1 million machines, this is what they do, and this is how they sell it. That's what you have to do. You sort of have to mirror your industry. Yeah. Sorry for.
I just want to make sure I understand the basics. You have a product, you've designed the product, you haven't sold it yet, but you have a name for it.
Right.
And clearance search, and so you file a registration, and you say you intend to use this in commerce.
Right.
And the examiner will say, okay, you have 3 years, right?
Yes. Yeah.
To demonstrate it, but if you do demonstrate it, then it is registered.
Yes. Yep.
Okay.
Yep.
And
yeah, the process. Just to be clear, so you file your application.
Right.
Examiner reviews it, make sure everything's in order. They may question your description or something like that, and then they publish it.
Right.
Like this book right here. These are all published marks.
Okay.
So then somebody has 30 days to oppose. If they don't oppose, probably within a couple of months, if it's an ITU, they'll issue a notice of allowance, and they'll say, hey, on August 1st, your notice of allowance issued. You now have 3 years. You have until August 1st, 2014 to prove use. And then you have 6 months to either show use or request an extension of time.
Okay.
So you have, what the trade-off is, we'll give you extra time, but you got to keep paying us money to keep that application alive.
Yeah.
Yeah.
So if it's a bottle of water and I put up a website and I offer to sell these bottles of water, that's not use yet.
Right.
Okay.
Right.
If I get an order for a bottle of water, but
Right.
I haven't delivered it yet, that may or may not be used.
Right. It's probably more towards it is use because you just
Get money out of it. And if I actually delivered the bottle of water,
Right.
that's use.
Yeah. Yes.
Yeah, are there any usage requirements for web domains?
Websites, you mean, or?
Yeah, so for example, if I take out some sort of web domain, something.com,
Right.
and just never use
From a trademark standpoint, no. You'll have a domain name, and you can have that forever. As long as you keep paying your domain renewal, you'll have that URL. And nobody can take it away from you unless you fail to pay your, whatever it is, $20 or $30, something like that. But if you were trying to take that domain and turn it into a trademark, eventually you'd have to have some use to substantiate the trademark claim.
Is visitation of the domain by others considered use?
Well, it depends on what your services are. If you're a website that provides information on engineering services, okay, and that's what your description of your application is, and you've got a website set up and it does all of that, and you got commerce going back and forth, yes, that would be use. I'm hiding in the corner here. All right. There's some more benefits. You get the registration. Now you're putting people on notice. Oftentimes, when someone does a search, they'll find that you've registered your mark. So they may be less inclined to go into that field using that trademark. So it's a deterrent. You can deposit it with the customs. So at the border, if you're selling products, you may have a right to stop infringers from coming over the border. You get to sue in federal court. May be important if you have to go after, that infringement in, Utah. So that guy doesn't have a home court advantage. You can sue him in the federal court, either, maybe where you are or there. Profits and damages. It can happen, but you have to prove it. You have to prove what happened, what monetary damages affected you. Limits on grounds for attack. That's called incontestability. It tends not to be a major issue for most trademarks. And obviously criminal penalties are around for counterfeiting. I'm trying to go through this fast. Yep.
If I register a trademark, say, for a new type of sporting good, I have a website up, and then I see it's being offered on a Chinese manufacturing website, what are my remedies?
The Chinese company or somebody else has it?
It's a Chinese company. They basically copied my website,
right.
used my name, offering it for a
right.
third of what I am. From a trademark standpoint,
right. If they're shipping products into the U.S., you could have, you could claim an infringement because that product's coming in, and you can hopefully go after them under a trademark.
How long does that take to stop the shipping?
It depends.
Well, someone is doing what?
I mean, what are you trying to do? Are you trying to go to the customs and try to stop it there, or are you trying to go to court? If you go to court, you're going to get it done quicker than through customs.
Really?
Yeah. Well, you're going to sue for an infringement.
Going to court could take years, right?
No. If that's immediate harm, you'd go in there and say, you got to stop.
Right.
This has to stop. I need an injunction. I need a preliminary injunction because if they get that container gets into the U.S., we're never going to find it. So, and that's what the litigators and the courts are used to dealing, especially in New York, is those kind of situations.
So after they.
And that's probably the biggest effect. They stop it from coming in. Now they got to go someplace else.
So you issue an injunction or cease and desist order.
Right.
They stop it, and then they go to customs and they say, "Don't let this in."
Well, customs it's an option, but think about it. Think about customs guys.
Someone sues me, they win. How do they stop me from?
How do they stop you from?
How do they know I'm still shipping in years?
You probably have an order against you, and you violate that order, you're probably going to go to jail. So you want to respect that court order. If you don't want to respect it, then these guys will continue on and do it. And there's businesses out there that do that all the time. They just change entity names and then they keep moving on. So you can skirt the law, but I don't know. Eventually you're probably going to get caught.
He said if the company's in China doing it. How do you stop a Chinese company from importing to the United States?
Try to find if there's a local distributor, local representative somehow, some way, and stop it. I guess you have to find out who's, obviously you don't want to go to China to try to stop the problem. You want to try to stop it here. You also, there's potential if they infringe your copyright, took everything, you may have a copyright claim against them. If they're using a domain name, you may have the ability to try to, get the domain back. Some of those choices there. Registration, I think we've talked about this too. We talked about, does it make sense to register? Slogans, it's short term. Why register it? It's going to be gone by the time the application gets looked at. Seasonal products represent a company that is in the candle business. So seasonal candles, they have many, many different names for them. They just make them up. Bubbleberry, whatever. And they just proliferate those. But it changes. Next year they'll change the name. So oftentimes it's quick clearance search, making sure that they're not infringing on somebody's existing rights, but they're not going to go through a registration process. Is your mark, distinctive, or is it descriptive? Should you register it? Should you wait till you have some reason for registration? Some of those things you should look at. If you don't register, you still have a common law trademark, and you can look at those rights, from a protection standpoint. Yes?
I was just thinking maybe we should wrap it up.
Okay. The rest is, let's just take a look. The notices, TMs and registration notices, the life of a trademark, keep renewing it, usage rules, usage, enforcement, enforcement is, here's some examples of people who didn't enforce their trademark and they lost it. Xerox has a campaign now, because Xerox, they get, give me a Xerox. They want people to understand that that's a brand.
We've been doing that for 40 years.
Yeah, right. So it could be, Google could be faced with that at some point. Google this for me, would you? What does that mean? Does that mean use any search service, or does it mean Google service? So, some of that could happen. And John was probably around here when Escalator was lost, but I don't know if anybody else has. It's a joke.
How did they get lost?
I'm pointing to him. He's not. What happens here is they become almost synonymous with the product. Escalator, at one time it was a escalator. I don't know, maybe moving steps was the descriptive term. And then everybody got sick of saying, escalator, moving steps. So they just said, we'll call it an escalator. And then it just became an escalator. And they lost the significance as a trademark. It didn't identify anything. It just identified, the moving steps. Aspirin. Bayer had aspirin. It was a trademark. Aspirin was a special, drug until it just probably came off a patent and just sort of became a generic.
That's the problem with having too good a trademark.
That's right. And then what happens is the marketing guy says, I don't care. I've got a successful product. I don't need a trademark. I'm just kidding on that. But yeah.
For example, Coca-Cola. So Cola, kinds of colas out there, for example.
Yeah. Yes. Yeah.
I got a question on usage, and it might be a little bit out of your expertise, but I'll ask it anyway.
Okay.
The placement and size of these marks. For instance, I've done artwork over the years with designing logos where I can move things around.
Yeah.
And I was never really sure how big to make the register mark or the TM mark, or where to place it, how close to the name.
Right.
Is there guidelines, standards on that? Or all about that?
If you go and Google some of the if you Google search using the Google service, Google branded searching service, you probably see some company, profiles and how they, recommend to their employees how to do it. Legally, it's just a notice. So if you want to be creative and you want to hang it off the lower top or the bottom, top or bottom, it's really, not anything magic about it.
I know sometimes they get touchy about these things, particularly like company logos.
Yeah. Oh no, you can't put logo, or you can't put registration notices on a logo. I mean, it's just, the artistic element is gone. So yeah, it's a battle. It's a battle. It's a battle. Like television advertising. No one's going to see notices on the bottom, so you kind of give up on that point. But if you can do it in a way that's conspicuous, at least one time,
I just thought they had a scanner, not the size.
Size of the symbol? No, it's all going to be dependent on what medium you're in. things like that. So, and there were a couple at the end here. I think you'll sort of look at them, hopefully for enforcement, for your enjoyment. Chewy Vuitton. They won. So there's a company out there that has a product called Chewy Vuitton, and they were, sued by Louis Vuitton and spent a lot of money going after them, but they eventually lost. And this is a little older now, but I don't know where they Porsche went after Crocs. So Crocs may have went to a trademark lawyer and said, "Hey, I want to use Cayman for a Croc. Can I do it?" Go ahead, no problem.
Somebody called them Tupperware for feet.
Yeah. So that's it.
After the meetings, sometimes people like to get together and go down to Archie Moore's for a drink. Is there anybody here interested in doing that? We have one person, except Chad. Hey, Chad. A couple or three people.
Talk for a few minutes if we can do that.
Yeah, there may be some people who already know how to get there. I think, Chad, you know how to get there. So if people don't know how to get there, they can follow him. I don't think I'll be joining you because I'm just beat. But I want to thank you all for coming. And next month, we will not be in this room. We'll be over in the Kelly Center, and I'll be sending out an email. And Mark is going to do his presentation. And what is the title of it again, please?
How to get your patent in half the time.
Half the time of what?
Of what it takes now.
Oh, okay. That sounds like a good one.
The presentation is only half an hour.
Great, very good. Well,
Where's the list?
Yeah, there should be a list somewhere. I don't know where it is, but I'm sure we'll be able to find it. Anyway, thank you for coming, and stay dry in the hurricane.